This will be a 1-minute warm-up for the literary portion of the RPR. Ready?
The power of suggestion means many different things to many minds. It is coupled with the idea of hypnosis, where the operator is able to make the subject think, so, say, or imagine anything he chooses. That is possible through the abnormal condition of the subject. The means and methods of inducing this abnormal condition are not generally known, although some practitioners have hit upon various ways of bringing on hypnosis in some subjects. But what is to be discussed is the fact of suggestion itself. Generally considered, and as it affects all men, people are not aware that they act almost entirely under suggestion. From our birth, we are surrounded by those who suggest certain ideas to us as true, and we follow these suggested ideas. There is very little original thought anywhere, and particularly is this true in those lines to which the public pays the most attention. The red marks. Mm-hmm.
This will be the 180 literary for the RPR portion. Ready?
Imagine you are sitting in a courtroom. You've just been chosen as a juror after what seemed endless questioning. Have you ever been arrested? Has your wife, your son, your grandfather? Do you have a bumper sticker on your car? If so, what does it say? The questions go on and on. Some seem pointless, others dig deep and force you to analyze this process of justice. Can you presume the defendant is innocent, even though charged with murder, rape, child molestation, and 7 other counts? Under our system, you must be able to adopt that state of mind and hold to it unless and until the defendant is proven guilty beyond a reasonable doubt. A difficult task, to be sure. As the judge takes the bench and you look around, you realize you are special. Perhaps it occurs to you that as an American, there are basically only 2 duties you may be required to perform as a citizen: military service and jury service. You become aware of the awesome power you have as a juror in America, to grant millions of dollars in damages, to decide if someone is guilty or not guilty of a crime, and in some states, even the power to decide if another human being should live or die. Once you return a verdict of not guilty, no one can change it, not even the judge. There is no appeal from a not guilty verdict. Now, it wasn't always so. In the 14th century England, juries could be locked up in jail without food or drink until they reached the verdict that satisfied the judge. And if the judge decided that the jury reached the wrong decision, he could convene a second jury to convict the first jury of returning a false verdict. Juries existed as far back as 2,000 to 3,000 years ago in ancient Greece. The first jurors were witnesses who had seen the crime or transaction, but in the course of time, the original jurors needed more information, and they called in other witnesses whose credibility had to be examined and weighed. Gradually, the jury became the finder of facts that it is today. The right to trial by jury as we know it originated in England in the year 1215. A group of barons were upset because King John was issuing decrees against them without giving them a voice. The barons, jealous of this violation of their rights, confronted the king in his tent on a meadow called Runnymede along the road to London. They demanded he sign a paper guaranteeing various freedoms, including the right to trial by jury. History was made as he backed down and signed one of the most important documents in history, the Magna Carta. Thus began the cherished tradition that America inherited and has struggled to uphold from its very birth. When Thomas Jefferson wrote the Declaration of Independence, he listed as one of the grievances against English rule, quote, "for depriving us in many cases of the benefits of trial by jury," close quote. And when General Eisenhower spoke to his officers on the eve of D-Day in June 1944, he reminded them that one of the freedoms they were fighting for was the right to fair jury trials, a right that had been trampled on by the Nazis. This is not to say that the right to a trial by jury guarantees a perfect trial. These are criticisms of trial by jury. Some will say that it takes too long, that a jury trial costs too much money. Some people say that jurors cannot understand complex issues. They are too easily swayed by emotions or by sharp lawyers. I must admit that such attacks on the system do have some validity, but they are outweighed by the fact that the jury trial is still the best protection we have against injustice. It is one of the best examples of our democracy in action, representing the judgment of a cross-section of the community, not a judge or police officer or government official, but the people. Finally, it has become a marvelous educational tool. Every day across the country, thousands of Americans pass through our courtrooms as jurors, learning about their Constitution and their Bill of Rights, and for a few hours or a few days rising to a new level of responsibility. Many people are not aware until they sit as jurors through their first criminal trial that the prosecution has the only burden of proof. It is the prosecution's job to prove the guilt of the defendant beyond any reasonable doubt. At the start of the trial, the defendant is presumed innocent and does not have to do anything, does not have to say anything, and does not have to prove anything. That is a basic rule in our jury trials, and that is why the prosecution always presents its case first. There are times when a defendant may elect to waive their right to a jury trial and instead wish to have their case heard by a judge or panel of judges. This is often used when there has been a lot of negative publicity about a case, and the defendant perhaps may feel that because of that publicity, it would be difficult, if not impossible, to find an unbiased jury. Thank you for your time here today, gentlemen.
My name is Teresa Brown. I'll be giving this portion of the RPR. We'll do a 1-minute warm-up for the jury charge. Ready? Begin. You have been selected and sworn to determine the facts and render a verdict in the case of the Commonwealth of Pennsylvania versus Robert Green, who is charged with 1 count of robbery, 1 count of aggravated assault, and 1 count of firearms not to be carried without a license. As I told you at the beginning, I will now instruct you as to the law you must apply to this case. The law applicable to this case is contained in these instructions, and it is your duty to follow these instructions. You should consider these instructions as a whole. You may not pick out one instruction and disregard others. I caution you not to allow sympathy, prejudice, or any emotion to influence you. It is your duty to base your decision strictly on the evidence. The evidence which you are to consider in reaching your decision consists of the testimony of the witnesses which you have heard and the exhibits which you saw introduced. You must consider all of the testimony of the witnesses and the exhibits, but you must not consider any testimony or exhibits to which I have sustained an objection or which I have ordered stricken from the record. This will be 5 minutes of jury charge at 200 words a minute. Ready? Begin. Ladies and gentlemen of the jury, in giving you the law in this case, the court wishes to make it clear at the outset that the court will not discuss the facts because that is your main function. The court will simply give you the principles of law which apply to criminal cases in general, and then discuss with you the elements of the crime which is charged in this indictment. The function of the court is to conduct the trial in an orderly manner, to rule upon questions of law arising in the course of the trial, and to instruct you as to the law which applies to the case. It is your duty to accept the law as the court states it to you, and you should consider all the instructions as a whole. The function of the jury is to determine the facts. You are the sole and exclusive judges of the facts. You should determine the facts solely from the fair consideration of the evidence. What the verdict shall be is your duty and responsibility. It is your own recollection of the evidence that will control during your deliberations in the jury room. The statements of counsel are not evidence. They are only intended to assist you in understanding the evidence and the contentions of counsel. The indictment itself, which you may take to the jury room with you if you desire, is not evidence. It is merely the formal manner of accusing a person of a crime in order to bring him to trial. You must not consider the indictment as any evidence of the guilt of a defendant or draw any inference of guilt because he was indicted. In this case, ladies and gentlemen, as you are all well aware, there are 2 defendants. In giving you these instructions, I will refer mainly to the defendant because what I say applies to each defendant. In all criminal cases, there are certain important rules that you must bear in mind. Among those is what we call the presumption of innocence, the burden of proof, and reasonable doubt. In every criminal case, the law presumes a defendant to be innocent of the crime charged. The law permits nothing but legal evidence presented before the jury to be considered in support of any charge against the defendant. The presumption of innocence alone is sufficient to acquit a defendant unless you are satisfied, beyond a reasonable doubt, of the defendant's guilt based on all the evidence introduced in the case. A reasonable doubt may rise not only from the evidence introduced, but also from a lack of evidence, since the burden is always upon the government to prove the defendant guilty, beyond a reasonable doubt, of every important element of the crime charged. There are two types of evidence from which you may determine the truth as to the facts in any given case. One is direct evidence, and the other is circumstantial evidence. Direct evidence is the testimony of one who states he has actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is the proof of a chain of facts and circumstances indicating the guilt or innocence of a defendant. The law makes no distinction between the weight to be given to either type of evidence. You should weigh all the evidence in the case. After weighing all the evidence, if you are not convinced of the guilt of the defendant beyond a reasonable doubt, you must find him not guilty. You as jurors are the sole judges of the credibility of the witnesses. In other words, you alone are to determine whether to believe any witness. If there is any conflict in the testimony, it is your function to resolve that conflict and to determine just where the truth is. You should give the testimony of each witness such weight as, in your judgment, it is fairly entitled to receive. Now, ladies and gentlemen, the weight of the evidence is not necessarily determined by the number of witnesses testifying on either side. You should consider all of the facts and circumstances in evidence to determine which witnesses are worthy of belief. Both of the defendants have taken the stand as witnesses in their own behalf. With reference to such testimony, the court instructs you that the defendants have a right to become witnesses in their own behalf. Their testimony should not be disbelieved just because these witnesses are the defendants. In weighing their testimony, however, you may consider the fact that the defendants have a vital interest in the outcome of the trial. You should give their testimony such weight as, in your judgment, it is entitled to receive. Ladies and gentlemen, as the court earlier indicated to you, there are two defendants on trial. Each defendant is entitled to have his guilt or innocence as to the crime charged determined from his own conduct and from the evidence which applies to him, as if he were being tried alone. You may find any one or more of the defendants guilty or not guilty at any time during your deliberations. You may return your verdict of guilty or not guilty with respect to any defendant. In the crime of robbery, with which these defendants are jointly charged in the indictment, the state must prove beyond a reasonable doubt that the defendant took property of some value from the owner against the will of the owner, and having carried it away, took such property without the right to do so, and with the specific intent to steal it. It is necessary that the property taken away have some value at the time of taking. The size of its worth is immaterial. The offense is not committed where the property is taken with the full knowledge and consent of the owner, or one authorized to consent in his behalf. You should consider the case of each defendant on its own. If you find from all the evidence that My name is Teresa Brown, and I'll be doing the questions for the warm-up of this portion of the RPR.
And my name is Frank Vasile, and I will be the answers.
Ready? Begin. Mr. Martin, good morning.
Hi.
My name is Robert Waller. I'm a lawyer. I represent SEPTA. We're here today to take your deposition in the lawsuit that you've brought against SEPTA. Have you ever been to a deposition before?
No.
Okay, it's questions and answers. I get to do the questions, you get to do the answers. The woman seated to your left is a court reporter who's going to make a word-for-word transcription of today's proceedings. It's very important that you understand my question before you answer it. If you don't, please tell me that you don't understand what I'm asking. I'll be sure to ask it in a way that you do understand, okay?
Yes.
If you need to speak to your attorney at any time during the deposition, just say so. He'll be given a chance to do that. Where do you live?
239 Wellington Road.
And where is that?
In Philadelphia.
How long have you lived there?
Since July.
Of this year, 06?
Yes.
Where did you live before that?
At 440 Lankenau Road.
And where is that?
It's in Philadelphia.
Also in Philadelphia. How long did you live there?
About a year and a half, almost 2 years.
Where you're living now, do you live with anyone?
Yes.
Who is that?
Lauren Barkley.
Okay. Anybody else there?
No.
This will be the RPR section of the Q&A at 2:25. I'm Teresa Brown. I'll be the questions.
Frank Vasile, and I will be the answers.
Ready? Begin. I'm going to show you what's been marked. If you could just look at this diagram, which has been marked as State Exhibit 3, does that area go into the area where Ms. Frost was living?
Yes.
When you indicate that this is Dunn Street, going back down towards the intersection, is that correct?
Yes.
Now you're indicating you saw a group of younger kids and that they were partway up the street, is that correct?
There were kids further up the street here playing around, and there was like a group of kids somewhere in that block area. One of these porches here, they were like sitting on the street.
Okay, during the course of, did you recognize the other person that you indicated Ms. Frost was speaking to?
No, I did not.
When you began speaking with her, was that person male or female?
I'm not really sure. I can't remember.
Did they leave at that point?
No, they remained seated.
Now, during the course of talking with Ms. Frost, what happened? Did something happen during that time?
We were sitting there. A couple gentlemen came up and asked for change for a $10 bill. I told them I didn't have that. They just continued to walk up the street.
Did you ever see these individuals before?
No.
At that point, first of all, you said it was about 4:30.
Yes.
It was light out.
Yes.
Are these individuals, after they walked by and asked you for change, what happened then?
I guess they continued up the street. I'm not really sure where they went to. I turned my head to look down the street a second, looked back up, and I was staring down two barrels.
When you say you were staring down two barrels, describe what you were referring to.
I had two guns pointing in my face.
Were you still on the porch of the house at this time?
Yes, I was actually on the steps leading to the porch.
Now I'm going to ask you if you could, again, look at this particular picture. Do you recognize that house?
Yes.
Could you tell the jury what house that is?
That is Janet Frost's house, I would imagine.
Could you point to the area where you would have been standing when you first came into contact with the two guns?
Approximately the third step here. 1, 2, 3 steps. Bottom step there. I was standing about there.
Do you know where Ms. Frost was when that occurred?
She was sitting right there, right where that chair would be.
So are you saying that there were chairs in that area at that time?
Yes, 2 chairs, I think.
Thank you. Now, the individual that was pointing these weapons at you, was this person male or female?
Male.
Had you ever seen that person before?
No.
Did the individual say anything to you once you realized you had two guns pointed at you?
Demanded money from me, told me he was starving, didn't eat in a couple of days, just demanded the money from me.
You indicated that you saw 2 firearms?
Yes.
Are you familiar with the difference between a revolver and a semi-automatic firearm?
Yes.
Did you notice whether or not what type these 2 guns were?
To my knowledge, they appeared to be .22 caliber semi-automatic.
Both of the firearms?
Yes.
I assume he was holding one in each hand?
Yes.
Now, after he makes a statement to you about demanding money and that he hasn't eaten in a while, how close was he to you at that time?
Not even a step, pretty much in my face.
Could he reach out and touch you if he wanted to?
Yes.
Did he make an attempt to remove anything from your person?
Yes, he made attempts to get into my pocket.
Describe how he did that.
Just pretty much, I guess, putting 2 guns in one hand and just grabbing at my pocket with the other. He was still pointing one at me.
During the course of this, well, first of all, what did you have in your pockets at that time?
I'm not sure. I know I didn't have money for lunch that day, so I only had a couple dollars. I'm not sure how much it was, just a couple dollars, I guess.
Do you know whether or not he actually was able to remove that?
No, I can tell you he never actually removed the money.
Could you describe what type of clothing you were wearing?
I really can't remember the clothing. I don't know what I was wearing that day. I know I was wearing a pair of boots that I loved. I don't have those anymore. That's all I can remember about that day.
When this occurred, did you try to resist him going through your pockets?
Yes.
What did you do to resist?
Just kind of batted his hands away and took a step back.
Having these 2 guns pointed in your face, were you afraid at that time?
I was slightly afraid. I would say yes, I was afraid.
Did he say anything else to you during the course of this?
Just halfway through the ordeal, he fired a couple warning shots into the ground and pointed the gun back at me, asked me if I wanted to get shot.
Do you recall what he did with the other firearm?
No, I don't.
But at that point, he had 1 gun and fired it into the ground.
He still had 2. He held the 2 guns. He pointed the one down, fired it into the ground.
Was that on the area of the porch where this occurred?
Yes.
When that happened, how close were you to this individual at that point?
We were still pretty much maybe a step or step and a half away.
During the course of this interaction, are you facing him?
Yes.
Are you able to look at his face?
Yes.
Did you look at his face?
Yes.
After he fired the warning shots, do you recall how many he fired?
Maybe 2 or 3 of them, I'm not sure.
When he does that, what do you do?
I kind of pretty much froze then. I really don't remember exactly what I did.
At some point, did you attempt to leave?
At some point there was a distraction behind him which made him turn around. At that point I began to run.
When you say a distraction behind him, he is facing you.
Yes, his back was to the street.
So something happened behind him in the area of the street?